Good afternoon. I'm speaking to you today as a settler from my office, which is in the traditional territory of the Anishinaabe, Huron-Wendat, Haudenosaunee, and Ojibwe Chippewa peoples, the land that is home to the Métis and most recently, the territory of the Mississaugas of the Credit First Nation, who are direct descendants of the Mississaugas of the Credit. We recognize and deeply appreciate their historic connection to this land. We also recognize the contributions of the Métis, Inuit, and other Indigenous peoples, the contributions they have made both in shaping and strengthening this community, in particular our province and country as a whole. I wish to pay my respects to the many Indigenous people who live and work here today, and I acknowledge that many of you, if not all, have faced the pain of racism in your own ancestral homeland. My name is Justice Barnes, and on behalf of the Association of Justice and Treatment Professionals, it's a pleasure to welcome you to today's special speaker series. And we are pleased to have Robin Parker to share her expertise with you today. Robin Parker practices criminal and human rights law and investigates workplace human rights issues for academic institutions with a focus on sexual violence. Robin started a career as a federal prosecutor. She worked on wiretap, organized crime, and terrorism cases and received an award of merit for her service. After leaving government, Robin was appointed by the federal court to assist with the security certificate litigation cases. She expanded her practice to include the regulated professions and representation of witnesses. She has testified before the Justice Committee on Victims' Issues and assisted complainants across the country. In 2024, she was awarded the Victim Services Award of Distinction by the Attorney General of Ontario. Robin works in Indigenous communities in Northern Ontario, Quebec, and the Northwest Territories. She has written about this work, including a chapter in Transnational and Cross-Border Criminal Law, Canadian Perspectives about Indigenous rights at the border. In 2008, Robin received an award of distinction from Oxford University for her Master of Studies in International Human Rights Law. She's a certified workplace investigator, University of Toronto, and is trained in a trauma-informed approach by the National Institute for the Clinical Application of Behavioral Science and the Crisis and Trauma Resource Institute. She's pursuing a certificate in conflict management and mediation at Conrad Goebel College with a focus on restorative justice practices, and has received her transformative mediation certification. Robin is passionate about legal education and has been an instructor for Osgood, the Advocacy Society, the OBA, the NJI, and the Law Society of Ontario. She's a former director of the Criminal Lawyers Association, a former board member of the House of Compassion, Toronto, and a co-founder of Indigenous Voices Awards. She paddles competitive dragon boat, loves backcountry lakes, winter, and being with her daughter's mom. So Robin, I'm going to turn this over to you, and you could sort of engage Robin by putting your questions into the Q&A. We will get into the Q&A at the end of Robin's presentation, or at any time Robin wants to engage with it. So with that, Robin, over to you.
Hi. I wonder if people feel comfortable turning on their cameras. That would be great. Then I could see you. But if not, that's fine too. Just sort of be in the space where you are. I know it's your lunchtime, so you're probably all eating your lunches, and that's fine too. I'm not sure what your backgrounds are, other than you work you in some way in relation to drug treatment courts or wellness and treatment courts. I didn't know Kopi was going to read my whole bio. so that was kind of embarrassing. But the thing about my bio that's funny is that really all I want you to know about me before I give the talk, is that I have been a lawyer for a long time and I've done a lot of different things, and I've represented pretty much every side of sexual assault cases. I have prosecuted them, I've defended them, I've represented complainants, I have investigated them and made findings of fact and recommendations for universities inside their internal complaint system, and I've been a complainant myself. And so my thoughts and reflections on this and my own experiences come from that place. And I think that's one reason why people keep asking me to come back and give this talk. In the talk, I'll explain why I started speaking about it, but I'm getting better at doing it, but it can be a challenging thing to talk about sometimes. So I hope it's useful to you and that it helps you out when you move forward, and that we can create little kind of places or opportunities for change, just little small wedges or little stones thrown in a pond. If many people throw many, many small stones in a pond, the whole surface is disrupted. I know that you are all legal professionals of some type and that you're pretty gritty. You wouldn't be here today if you weren't. But every day is different, of course, and your ability to listen and engage with difficult subject matter could change according to the day. So we're here today to talk about difficult things. And if you feel that you can't engage or you need to leave, please do whatever you need to do for your own self-care. So please be gentle with yourself. I gave this talk recently as the keynote at the Alberta Crown Conference. And at the end of the conference, I'm often approached when I talk in person about this subject matter by people who really want to share that they had also experienced sexual harm as a member of the legal community, and that they want to share and talk about that. And I will say that that happens to me universally every time I give the talk, including when I've made this presentation through the National Judicial Institute at conferences with judges. So, of course, it's a problem that's universal. But this woman was very interesting. When she first approached me, I thought that she was going to ask, she wanted to share her own story of experiencing harm or someone she knew. She wanted to talk about her experience of the legal system, from her position as a crown. But that wasn't her question. What she said to me was, I can't figure out your talk. She said, what side are you on? And I was like, you know, great question, very philosophical. And I was like, well, I don't, tell me more. What do you mean? What do you mean by this question? What side are you on? And she's like, I can't figure out, like, are you a crown? Are you a defense counsel? Like, are you a victim's rights advocate? What side are you on? And I was like, well, I'm on every side, not to be too, Buddhist about it, but I'm on the side of transformation. I'm on the side of addressing things from the root. I'm on the side of this is a vast social problem that harms everyone it touches. And this, what we're doing now, it isn't working. And so I'm on the side of changing things. And the binary that we use in criminal matters is absolutely important. And it's honed through literally generations of the development of the criminal legal system, and the adversarial process, and the checks and balances that are put in there have been put in there as a result of injustices that have been experienced. That's how we built the common law. But it's a binary. And that binary isn't useful when you're trying to address a root cause of something. Addressing the root cause of something is subtle, it's complicated, and it's challenging. Justice Barnes acknowledged in his land acknowledgement that many of us here, maybe all of us here, have experienced and been touched by the experience of racism in our lives. On the one hand, there's a binary around something like that. It's painful, it's bad, it's wrong. But when you start addressing the root causes of racism and how do you change it, it becomes a lot more subtle and a lot more complex. And so whose side are you on is a great question. And I'm really, really grateful that I was asked it. And that my answer is, what I just said to you now, which is the side of transformation and the side of change. So in 2018, I was sexually assaulted. It wasn't the first time. I'd been sexually assaulted as an undergrad, which is how I ended up in law school. I was fueled by an idealistic fire. I wrote on my law school application that I wanted to make the legal system better from the inside, and I suppose I still do, thankfully. But that's why I said I wanted to be a prosecutor, because that's what I believed was the way to achieve that. This day in 2018, that I was sexually assaulted for the second time. I'd been a criminal lawyer for 22 years, knowing more than I did 30 years earlier in 1988 when I had decided not to report. I immediately made the exact same decision. But when I got home that afternoon, I couldn't make myself go inside my house. My daughter was inside. She was 17 at the time. And I knew that there was no way I could go in the house and pretend to her that I hadn't just been harmed without doing greater and further harm to myself. But I also at the same time had no way to explain to her why I wouldn't be going to the police without expressing bitterness, or worse, a loss of idealism that has fueled my career. I'd worked so hard to instill in her the belief that our lives matter, that our actions make a difference. And giving up on the justice system that I had sacrificed so much to be a part of, first person in my family to go to university, that kind of background, it felt like the antithesis of that. I actually wrestled with this. I paced up and down beside the laneway of my house. I got back in. I drove a neighbor to work. I did all kinds of things that I would have been cross-examined about had I had a trial. But eventually I decided that I had to report, because I couldn't go inside my house unless I did, and I needed to go inside my house. Of course, I was not alone in my struggle to decide whether to report. One of the biggest parts of the pro bono legal practice I have advising complainants is talking to them about whether they, what it would mean for them to report. In 2018, Stats Canada surveyed over 43,000 Canadians. Of the people who reported experiencing sexual violence in the previous 12 months, only 5% reported to the police. Since then, that number has gone up. It's 6. Now it's 6%. And this should be a breathtaking number for anybody, but especially for those of us here in this virtual room. Anyone who is aware of how much space and time cases of sexual harm take in the system, to think that that is 6% of the cases that are happening, to think of what would happen if we just doubled that number to 12%, I mean, the system would literally collapse. So the stats are a bit old, but they're the best that we have right now. We know that nationally the crime rate has been dropping pretty steadily, but that sexual assault numbers also seem to keep going up. The data is not clear yet on what the increase in those numbers mean, but it's starting to look like, as more studies are starting to come out. I just read one more recently about sort of the decrease of stigma post the Me Too movement, although there's some questions about that. So it may not be that rates of sexual violence are going up, just that rates of reporting are going up. But what we can say, if we take a snapshot of the last 25 years, is that all of the efforts we've made inside the criminal justice system to make it better for complainants or victims of sexual harm, they're not working, because the numbers are not going down and the amount of cases being reported are not going up. One thing I'm not going to ever say during this talk, and I try to avoid, is using convictions as a metric of success. And I'm going to get to a bit more about why I don't in a moment, but I will just flag that there for people who like to think of that as a metric of success. Of course, we know how low the conviction rate is. Of course, the Crown and defense bar like to argue about this, but the conviction rate is low. Let's just leave it at that. The DOJ did another study. I'll just give you this statistic as well. They asked sexual assault survivors to rate their level of confidence in the police, the court, and the criminal justice system overall. 2/3 of participants stated they were not confident in any of those institutions, and the percent who said they were confident and comfortable with those institutions was 2%. And of course, I do not fall into that 2% because of that story that I told you about how difficult it was for me to decide to report. And that's shocking, or it should be. It wasn't to me at the time, and it still isn't, but we should be shocked by that, right? Because this is our justice system. It doesn't exist independently from us. We are its architects. We're the builders of the justice system. And so we're responsible for it both individually and collectively. We build the justice system by how we show up in court and what we do in court every single day. So the problem I'm setting out here is our responsibility. We are responsible for building and creating the solution. 30% of women over the age of 15 report experiencing sexual violence. That's 30% of all the women that you know in every room you go into, including in every courtroom, in every police station. If you go into a jail, the number is going to be a lot higher. If you sort for race or disability or any protected ground, for example, 62% of Indigenous men and women over the age of 15 report having experienced sexual violence. So everyone here has been touched by it directly or indirectly, someone you know, someone you don't know, and all of us, because we work in the justice system and we're touched by what we see and experience, and our clients and the people who we are prosecuting, the people we're defending, the people we're judging, the people we're assisting, all of it. And for those of you who work in drug treatment court, undoubtedly many of your clients, whatever or however you describe your relationship with the people who've been charged and are going through drug treatment court, would have themselves been victims of sexual violence. And yet this conversation about did you report or would you report, I mean, of course, any woman in the system has had this conversation with multiple colleagues, crowns, defense lawyers, judges, police officers, and the resounding answer is a hard no. So what does that mean for us? We who know the most, who have so little confidence. The fact that sexual violence is so pervasive tells us that it is not, in the words of Adrian or of Miriam Kaba, a story of individual monsters. Those of us who have come to know people accused of sexual assault, either representing them or investigating them, or because they're in our family or they are our loved ones, maybe we work with them in other ways. We know this already. We have to think about this in a subtler and more complex way than holding to the idea that it is predators or monsters who cause this harm if we're really going to get to the roots of sexual violence. I am not saying that there aren't predators. I'm not saying that there aren't people whose behavior is shocking and extreme and where separation from society is the only way that we can deal with those people to make society safer. What I am saying is that based on my experience and my knowledge, my learning, and my studies, is actually quite a very small percent. I got into an argument with a woman on Twitter about this once, before Twitter became what it is now, back when we used to engage freely in a good social discourse on Twitter about how a feminist could be an abolitionist or defend people charged with sexual harm. And I said to her, well, if or when your husband or son or brother are charged with sexual violence, you'll want us. You'll want us to be defending them. And she said, you defense lawyers, you're always raising the specter of the innocent accused. Well, I said to her, you're the one who assumed innocence. I assumed that they were guilty. And she's not wrong about defense lawyers raising the specter of the innocent accused. It's a rhetorical position we often take. I don't like it because it implies that guilty people are less worthy than innocent people. And on a micro level, though, you'd better believe your client is innocent or be prepared to engage in the cognitive dissonance necessary to defend them if you're going to give them a vigorous defense. But on a macro level, what does that belief do? And what is our system doing to the people who are charged? And what impact does that have on a larger social scale? I believe that the way we prosecute and defend sexual cases of sexual violence and sexual harm may be doing the exact opposite of what the justice system intended, which is prevent crime and make us safer. Don't get me wrong. I absolutely believe in a full and vigorous defense in the face of a carceral system. If you are going to have a system where at the end, where evidence is called, right, and there's findings made by a neutral arbiter, and then someone could go to jail at the end of it, this is the best system that we have. But let me give you a defense lawyer's perspective on something that happens that doesn't often get talked about or see the light of day. Let me share this with you. I'm going to take you into a defense lawyer's office, and a young man, say he's 20, he's charged with a one-on-one sexual assault, what we sometimes in the system called he said, she said. There's alcohol involved. He's a university student. She's a university student. And the defense is honest but mistaken belief in consent. He looks perfectly wholesome. He's awkward as any 20-year-old you ever met. He's probably more comfortable gaming and chatting with people on Discord than talking to you in your office. But he's overflowing with this burning desire to tell you what happened that night. He wants to tell you how he met her. He wants to tell you what she said. He wants to tell you what happened. And he has this question in his mind, like he's confused. Why did she say this? How did I get charged? Like, why am I here? He doesn't understand. And he starts to tell you about that night, and you say to him, stop. I need to see the disclosure first. And when you get the disclosure, you review it with him. And only then, using carefully crafted questions, will you ask him what happened as you begin the job of preparing him to testify about his honest but mistaken belief in consent. And as you work with him, that light in his eye, which is that question, that little space, why did she do this? Did I do something wrong? Did I make a mistake? That light goes out. And it had better go out before he testifies. Otherwise, you haven't done your job. He'll have his trial. He'll be convicted or he'll be acquitted. I've been on every side of this case. I've prosecuted it. I've defended it. I've represented the complainant. I'm absolutely neutral about the outcome. I have no stake in this hypothetical. But one thing is certain. By the end of the trial, whether your client is convicted or acquitted, he has a profound belief in the fact, which has become a fact in his mind, that he was unjustly charged. And if he is convicted, he likely also has a profound and deeply held belief that he's been wrongfully convicted. And he's been wrongfully convicted because women lie. And if he goes to jail, what's going to happen to him in jail? At what point is he going to get access to really thoughtful, careful programming? I mean, he might be one of those few people who is able to reflect even on his own, to admit that he's done something wrong without help and assistance. But if you think about how hard it is to admit that you put the bowls away in the wrong order with the biggest one on the top and the smallest one on the bottom, and your partner says to you, why did you do this? And you say, I didn't do it. Susan did it, my kid. How hard it is to admit stuff that's easy. It takes a lot of skill and emotional intelligence to make an admission in this context. And at no point in that entire process will anyone in the system with any knowledge or training or skills have an open and honest discussion with him in which he can safely and be vulnerable and ask those questions and admit and learn. And this is where the actual purpose of the justice system is at stark odds with what people like to believe it's about. We may not be achieving our goals. Maybe the justice system isn't really about making people safe. That may be an incidental side effect, and I do actually think it is in some contexts. But of course, the purpose of the justice system is to determine how we respond to the antisocial behavior of one person, how the state responds. on behalf of society. And because of that and its carceral nature, we always have to stay in the microcosm and focus on the rights of the accused. And so here we get this tension that is very acute in sexual violence cases. It's also very acute in drug treatment court. But because of the social understandings of addiction, I think that you're able to do better work in that field than you can in the case of sexual violence. But we have this need to deal with this pervasive and corrosive social problem that we seem to be making no headway with. That's why I gave those statistics at the beginning. And the overwhelming need, on the other hand, to protect the rights of one person in the face of a carceral system that will permanently change the rest of their life. And so that's why I said I think we're making things worse, because we're harming not just the complainant through the process, but also the accused. And that's why I believe we need more options than the criminal justice system. Now, civil sexual assaults are growing. And one thing that's growing exponentially is the area where I do probably almost most of my work now is workplace and institutional violence cases. And the number and severity of the kinds of cases that I investigate on behalf of institutions it's just like a straight 90 on the graph. I investigate cases involving bodily harm, choking into unconsciousness, permanent. I had a case a couple of years ago where the person harmed had a brain injury, a permanent brain injury, and none of these cases were reported to the police, many of which wouldn't uh, uh, be candidates for a restorative justice process that I'm talking about now. So we know that the people are not reporting. And so what do we do? And inside the criminal justice system, you might be asking yourself, if you're not a defense counsel and you feel very frustrated because, if Robin said that young man comes into her office and they have that conversation, why doesn't she say to him, well, you could plead guilty? I kind of can't. And most defense lawyers really can't, because of the collateral consequences that have been put on sexual violence cases. In some jurisdictions, the fact of the charge itself is never even removed from a vulnerable person's sector check, even if you're acquitted. So the charge alone means that if that client goes to get past, they want to work in a daycare or at a skating rink, they will be flagged on a vulnerable person sector check. They won't fail it, but they'll be flagged. And then their employer will say to them, why are you flagged? And they can say, oh, I was charged with sexual assault, but I was acquitted. Okay, well, are they going to get that job? So this is why there's no guilty pleas. But funny enough, all of those things were added to cases of sexual harm because we saw this social problem that people weren't taking seriously because of myths and beliefs we had. And so what opportunities do we have for repair and healing? So after I reported, I had no idea what I was going to do. I honestly was just doing a one day at a time approach. I applied to myself the advice that I give to complainants who decide to report, which is if they come to a decision to report, then we say, okay, we've reported for now. Now he's on bail. Now he has conditions not to contact you. And there's so few places that complainants have the ability to make choices inside the system, that, knowing that at any time you can change your mind is very useful. I just want to point out that at the time that I started as a Crown, although I articled for the provincial Crown, started at the federal Crown, but while I was at the provincial Crown, I observed cases where complainants didn't want to continue, and there were arrest warrants for them to be brought to court to testify. So this idea of a complainant saying she wants to back out of a trial and the Crown respecting that has happened in my career lifetime. And in the North, sometimes complainants are still brought to court by the police. They wouldn't say that they're arrested, but the Crowns will send the police to their home and invite them to get into the police car, to be brought to court, to have a conversation with the Crown, just to make sure that they really don't want to testify. My case was at the downtown provincial courthouse where I started out my career. And I had spent so much time there as a young prosecutor that over the first Christmas, a mouse made a nest in my shoe, and there were baby mice in my shoe when I returned to work after the Christmas holidays. The idea of my colleagues in that building judging me, judging my credibility, seemed untenable to me. At the same time, I had the idea that if we had a trial, there would be a very good chance he would be convicted. I may have not been the most impartial, but I had done certain things. I had a recording of my own statement, so I didn't have to fight to the Crown about getting it. I recorded it on my own phone when I went and gave it. I had a lawyer assisting me. I know one or two things about testifying and giving evidence and being cross-examined. I felt like there was a pretty good chance he would be convicted. The accused was a first offender, but he'd been screened for jail, and not a not insignificant amount of jail. There was a breach of trust element. It wasn't a pen. He wouldn't have gone to the pen, but it was screened for a pretty hefty jail sentence on a plea. And I didn't want him to go to jail. I didn't want to perpetrate the cycle of violence back onto him. I didn't want to tear him down with trauma and punishment. I wanted to make sure that he understood what happened and that he wouldn't hurt anyone else. And I knew from my experience in the justice system that if he learned anything, it would be in spite of, not because of having a trial. One of the things that happens in a trial, and one of the things that Crowns often tell my complainant clients is they say, it's your opportunity to tell your story. The police sometimes tell them that too. And I always tell them that that's wrong. They will not be telling their story when they testify. They may have told some of their story when they spoke to the police, but it's pretty unlikely that the police might have asked them enough questions for the whole context to come. The part of their story that a survivor thinks is important to be heard. What they do in a trial is they give evidence. And that's not the same thing as telling what happened to you, being thoughtfully and carefully listened to, right? And having the person tell you back, I heard what you said. I heard that this happened for you. I heard that this is what you experienced. And then review the harm in the process. That's what a restoration conversation looks like. In the criminal process, there is no complainant I have ever met, ever, who left a trial feeling like they had told their story. Quite the opposite. And that's why more and more complainants are asking for a restorative justice process. Let me just go to that. It's why I asked for a restorative justice process. At first the Crown said no. She said no early and she said no often. Now there's a policy in Ontario. The sexual violence team, their policy is that a restorative justice process is a form of diversion. They view it that way. And so the policy now in Ontario is that a restorative justice process in cases of sexual harm or sexual violence is not permitted. At the time that my case went through the system, I don't believe that my Crown was aware of that. And in fact, that interpretation of the policy may not have been circulated until a bigger case went through the system after mine, which was Marley Liss. And Marley Liss's case came a few months after mine, and she spoke to the press, and the Crown spoke to the press. And then after that, the Crown was actually disciplined by MAG for having violated their policy on restorative justice cases. But at the time of my case, my Crown started having problems. I started lobbying for a restorative justice process, a circle, very, very early on. I started emailing the Crown. She would freak out. I have to disclose this. I would CC the defense counsel and say, like, I know you have to disclose this. Like, I know that. That's fine. Let's all talk about it. I understand that she scheduled a couple of judicial pretrials or had some judicial pretrials. Some of the judges were conflicted because they knew me just by coincidence. There's lots of judges in that building. Then they had to think about getting an out-of-town judge. There was starting to be delay, and so finally she agreed that I could do a restorative justice process. And I did, and I'm very pleased with it. And I was very pleased with what happened during it. It was very challenging. It was very difficult. And I can't talk about what happened and what was said in the process because we both have confidentiality agreements. But I feel very confident that I was heard, that he understood what harm happened to me in the full context of my life, and that the harm was not just done to me, but to my daughter, to my partner, to other family members, to some of my work colleagues. And he had an opportunity to share with me what it was like for him to go through the system. And that was interesting for me to hear, even having had the experience and knowledge that I had. After my case was over, I said nothing about it. I read about Marley's case. I reached out to Marley and made friends with her. I think she's quite an amazing advocate, and I urge you to look her up and follow her. But I decided not to say anything until a couple of years ago. I learned about a group of women who were fighting with the Crown about their policy. And they were being told no, that they couldn't have restorative justice processes. And a couple of these women were Black women. And one of them was very vocal, and she spoke to the press and she said, I don't trust, the person who harmed me is also Black, and I don't trust that he'll be treated well in the justice system fairly. Right. And so I want to have a restorative justice process, though, because I want to come into conversation with him and explain to him and make sure he understands how he harmed me. The Crown withdrew those charges rather than work on changing their policy, find exceptions, rather than allow those women to have restorative justice processes. And that's when I realized that, Marley Liss got a restorative justice process because she had a brave prosecutor who was willing to face the consequences and do what she believed was right. I got restorative justice either by accident or because of my privilege in the system, right? I got it because I was a problem for the Crown, but the only reason I was a problem for the Crown was because everybody knew me, because I had worked inside the system. And I felt that put a responsibility on me to use that privilege that I had, that I've gained over a career in the justice system, to speak out and to raise awareness. And I knew that people would listen because of that privilege. And so that's why I decided to start speaking about this, however challenging or difficult it might be for me, and really, I guess, whatever impact it might have on my career. I felt like it was my responsibility. I think we emailed around a title for the talk, and I think it said the title was Building Justice. And I talked a little bit about how the justice system is our responsibility. We build it every day by how we act and how we behave in court. And maybe there's laws that constrain us, but there's much that we can do. And the poet Rumi, the Persian poet, writes about how craftsperson looks for what is missing to perform their craft. So a builder looks for a rotten roof. A carpenter stops at a house with no door. And a water carrier chooses an empty pot. I take great solace in this poem, and I turn to it when I feel my idealism is at risk, because we are all craftspeople, all of us here today around this virtual fire together in this virtual room. We are justice builders. And a justice builder stops in a place where something is missing, a place of injustice. And it's unpleasant and it's uncomfortable. But when we feel that feeling, we should know that we are exactly where we need to be to perform our craft of trying, anyway, to create justice. Thank you so much for listening and for inviting me to share with you today.
Thank you, Robin, for this very personal and thought-provoking presentation. You've provided a presentation from a very unique perspective. You've been Crown, you've been defense counsel, and also you've been a victim of a sexual offense. And it's a very difficult and topic, and I don't see any questions. Somehow I'm not surprised. It's a kind of topic whereby it's heavy and the kind of topic that people will listen to and reflect on. And you have a perspective that very few people, I'm sure a very small percentage of people will have, given all the sites that you've been in. Since I don't see any questions, I just want to thank you for doing this. Not only does it take time, but also it takes courage and a deep commitment to see improvement. Mary Jane Ellis has just said, thank you so much. And I think she echoes what we all feel. So with that, we'll wrap up. I see, let me just make sure, Robin, before I go, because I want to make sure that I see a note or something in the chat. Oh yes, that was a comment from Mary J. Ellis indicating that she appreciates the benefits of restorative justice. So Robin, thank you so much.
Thank you. And I'm very easy to find online. So if there's anything I can offer to anyone who's here today, please don't hesitate to reach out and take good care. Thank you so much for inviting me to share my experience and my ideas with all of you.
Thank you.
Be well.
Okay, so good afternoon and goodbye. Thank you. Until next time.
Bye-bye. See you again.